Adams.
Good evening, Mr. Chairman, Vice Chair Davis, members of the committee. It's good to be back in front of you. My name is Will Adams. I'm here on behalf of the Texas Trial Lawyers Association, opposed to the bill.
Thank you.
I'm going to stray from my prepared remarks for a bit. I have listened, at least early on in this particular hearing, as to the purpose of the bill, and that is to affect or deal with folks who may not have actually been injured, or who may not have actually needed the treatment that they got, or who may not have actually needed to be helped with medical care. I want to speak from the perspective of Texans who are actually hurt and who actually need care but don't have the means or the access to get it. And that's what I want to focus my remarks on. Chairman Bonin, you are correct that this particular sub has been out for a couple of days, and for those couple of days I've tried to wrap my mind around the actual effects of this bill, and we talk about wanting to avoid unintended consequences, and there are those in this bill. And from listening to these wonderful doctors' testimony, what I have come to feels true. There are unintended consequences. One is that the cost and time associated with litigation will go up. Two, there will be two tiers of medical care, two lanes. One for those who have money and health insurance, and one for those who don't. It's inevitable. With the ultimate unintended consequence from what we've heard from the doctors is there will be a trouble or lack of access to care because of these things. The increase in cost and time will result from the change in F and G in 18001. This is the counter affidavit portion of 18001. 1801 was put in place 30 plus years ago to make sure that what should be simple and easy and efficient is that. That's why it was put in place. The 1801 affidavit does that. A defendant who wants to challenge that, say, no, that doesn't look right to me, has a process with a counter affidavit. It just requires that they hire someone who knows what they're talking about and states what they're talking about. It's that simple. Two lanes. And forgive me, I'm going to press through with unprepared remarks. Two lanes. This shows itself, and I'm going to focus on 18003, the affidavit that the non-hospital providers give. It gives a chance for those who have health insurance to get by easy. There's no contesting. But if you don't have health insurance and there's an outstanding bill, oftentimes with a letter of protection because they don't have the health insurance, then there's going to be a notice of intent filed. This is the big change in F and G. What once was a controverting affidavit now is a simple letter or email or even a form that says we are going to controvert this. Not going to say when or how or who's going to do it, but I promise we're gonna. And when that happens, the bill affidavit is dead. Depositions will be done. And because of these things, increased cost, pulling doctors into depositions will lead to doctors stop treating these patients.
Thank you, Mr. Adams. Madam Vice Chair.
So thank you, Mr. Chairman. I needed to ask a question of Mr. Adams as it relates to access to health care. I worry about that, just hearing the doctors talking about their ability to afford this change. But I had a broader question, and maybe you can help me with it. Do you know of any other industry that we regulate their payment through legislation like this? Do you know any other profession or any other services that the state has that we regulate the cost to the point that we're regulating doctors' fees? Well, any other profession that we do that?
I don't. Not off the top of my head, at least. And I am open to being proven wrong, but it doesn't sound like.
And so I'm asking that question because I've been sitting here trying to figure out, is there any other industry where we delve into their billing to the extent that we define what they can charge, what they can't charge, what they will take for usually it is my experience that people get to set their fee based on what they believe their services value is, and people use that based on that as a payment. And so I was just wondering if we as a state, since I've been here, I couldn't think of any other instance where we as a state have gotten into the business of regulating people's pricing for the services that they provide. So I was just curious if you'd had any indication of that.
Not that I'm aware of, Chair Davis, and it's more than that in this particular case. In the layout of the bill, it was presented as if the doctors choose Part A, and they take the 150% of workers' comp. That there's no hassle and they get paid. Right. We're not only setting a cap, but they don't just get paid if they agree to Section B. They're going to wait, sometimes 2 years, sometimes longer. It's going to be worse now.
Yeah, and so I'm going back to, I'm trying to understand the role that we're now playing as it relates to this industry and as it relates to this legislation, because we're changing the role of the legislature, in my judgment, from a policy to dictating now what we will do and what people will have to do if they want to do business with the state of Texas, in a much different way than we do in other departments where we procure services and or procure products for the state. This is a little different in that we are now defining what people will or will not be able to take. That's the way I'm hearing this. So I was just curious about that. The second thing is, as it relates to access to health care and the comments with regard to certain kinds of patients, the Medicaid patients, Medicare patients, the workman's comp patients. And so I envision that we have these different tiers of care based on the kind of patient you are. And would we as a legislature passing this legislation define these kinds of criteria so that we are now choosing what kind of patients gets what kind of care? I mean, because if I'm hearing the doctors, they're saying what it costs them to provide adequate care for Medicaid and Medicare is different than what we're willing to pay. And so I'm wondering, as a program that we put in place at the state of Texas, Medicaid is a program that we say we want to provide health care for certain kinds of patients. Are we now crafting legislation that's going to provide them less than adequate and appropriate care so that we are, in fact, creating a two-tier system as a legislature? I just want to know if we're going to start treating people differently because they're this kind of patient or that kind of patient.
I think we've heard
regulating that.
Yes, Vice Chair. I think we've heard that that's the case from the doctors, just practically speaking. If this kind of fee cap is imposed, many will have no choice but to move on, which is going to limit access to care, inevitably.
And the other thing, and I'm asking you because you've been here forever, and I understand, I don't mean that in a one, but you've heard this testimony, and you've been engaged in these kinds of negotiations with regard to what happens when people can't get health care or when it's challenged. You end up invariably, your profession's got to get involved. And the other part of this conversation was whether or not these folks are PI cases, personal injury cases. And so therefore, now we don't think we got to make sure that the PI cases are less or not able to get adequate care because of the fear of legal involvement. And so I'm just trying to hear us as a state, how we're creating all these tiers of folks and how we're going to mistreat Texans. And the legislature seems to be regulating these different tiers. And I'm just wondering, in earlier testimonies and questions about this kind of stuff, we always hear about this is because of litigation, or you're going to get drug in. This seems like, based on what the doctors are saying, they're pulled in because somebody's questioning their billing after a professional bill has been established based on their many years of service and knowledge, and now somebody says, no, you can't get that done because the insurance company doesn't approve that. All of this seems to stem back to the insurance companies to me. So I'm just trying to figure out how you all end up in the middle.
Well, I might be biased in my response regarding how insurance companies treat folks. They're the reason that I get up every morning, frankly. But I get your point, and sadly, there's already been created a different lane for people who have been injured. For example, in car wrecks, I have clients who have health insurance, whose primary care doctors who've treated them for a decade won't see them. I could tell story upon story, but they become second-class citizens once they're in that wreck because of things we hear at the beginning of this hearing, that automatically they're considered to be a fraud or a cheat or gaming the system. That's not the world I live in. That's not who I know. Those aren't my clients.
Right. And so that's what I was trying to understand. We as a legislature, because I'm very careful to think about our responsibility to people, the folks we represent, and Texans in general. So it frightens me to think that now the legislatures in the business are trying to regulate these kinds of the environment to the extent that we're now creating first and second, third class patients and folks, the kind of care they will receive. And I just want to make sure that we do what we can to protect the integrity of access to health care for everyone at a standard appropriate for everyone and not second, class. So anyway, I was just curious about that. Thank you very much.
My pleasure, Madam Chair. Representative Johnson?
I will.
Representative Johnson, how are you?
Oh, tired, as I'm sure we all are. Okay, I want to just kind of walk you through the process of the impact of this bill. For one, I mean, I think your point is well taken. I think I would love to see a provision in here that prohibits in-network providers from not seeing patients who are injured, who are on their plan. Let's start with that. Because you're exactly right. There are so many physicians that refuse to treat their patients who have health insurance. And these physicians are in-network providers. They're going to their in-network doctors, and they should not be allowed to refuse treatment. That is a huge problem that is contributing to people who don't bill their insurances because they can't get a doctor to take it. But secondly, let's walk through this. So somebody sends you a notice. So let's say you represent a plaintiff that went to a hospital, followed up with a primary care doctor or an orthopedic doctor. They had to get MRI, maybe they had to get some physical therapy, or maybe they had to have surgery, or fill in the blank. But most situations, the plaintiff has at least 8 medical providers-ish on a typical case. Sometimes more, sometimes less. But so let's say now you have filed your affidavit, so they've treated with the doctors, and the whole point of affidavits is to make it to where doctors don't have to give a deposition every single time proving up their medical records. But now, so they filed, now that you receive your notice of intent letter from a defense lawyer, what does that do to your bills? What do you have to do now as a plaintiff's attorney to prove up the medical care that your client has incurred?
Well, we start with B1 of the sub, and that tells us what happens when this, hey, I'm going to controvert someday, email comes across. It says that the 1801 affidavit has no effect except to prove the authenticity. That just means they're really they're really the bills. No effect as to reasonableness or necessity. And so to get to the end of the trial, we always look through the filter of trial and what we need to prove up to make sure we're representing our clients and they're being made whole. There's a blank in the jury charge that says what sum, if any, and it's reasonable and necessary medical expenses.
Aren't you going to have to depose all these doctors?
To get to that blank, you have to prove reasonable. You can either do it through 1801 or you have to use the doctor.
Right. So that's once they take the affidavit out, and you get the notice of intent, the next step is, okay, well, if I'm going to prove up my case, now I have to go notice 8 depositions from 8 different medical providers in order to prove up. And now I'm having to spend significant sums of money in deposition fees, court reporter fees, videographer fees that are now adding to the taxable court costs. And now the expenses go out the roof, right? And then the defense attorneys have to also pay to attend all of these depositions. And the defendant's insurance companies have to pay. And then when the plaintiff wins, the defendant gets to pay for it all a second time in taxable court costs. Just because we don't want to have an affidavit that saves all of that expense to both parties.
That's correct, but it's important to point out that we also have a duty to make sure that we are spending our clients' money appropriately. And if we've got a case where there are minimum limits or a smaller amount of limits, and we're having to watch the expenses, because that comes out of the client's portion in the end. That is client money. God bless these doctors, but we will have no choice but to subpoena them. And a subpoena comes with a $10 check. And that's not going to make them happy. And believe me, that's not what I want to do. Believe me, that's not what I want to do. I don't want to be there at all. I want to have it proved up appropriately by affidavit.
This whole the initial affidavit, but under the current system, if a defendant wants to challenge a bill, they can hire an expert and designate them, and they can come and testify. And nothing under the current rules prohibits a defendant from challenging the bills via an expert witness at trial if they feel like the bills are unnecessary.
So the current, I agree. The current 1801 says that if you have a bill affidavit that stands, that the counter affidavit is not successful against, it's sufficient evidence to prove reasonableness and necessity. It's not definitive. It's not to the exclusion of something at trial to contradict. It's sufficient evidence. So the current system is set up to protect against the abuses that you're describing. It is. There are affidavits that are getting struck, and they're getting struck because they should get struck. They're either not qualified or they're commenting on things they aren't supposed to comment on. For example, Chairman, causation. It used to be the fact where the counter-affiance would say this treatment was not reasonable or necessary as a result of the crash. It doesn't mean it wasn't reasonable or necessary for a condition or an injury as a result of the crash. Judges would routinely exclude that because it's not appropriate. And that's why that language was put in last session, that causation was not appropriate.
Right.
This is why things are getting struck, is because they're not good affidavits for one reason or another. I have cases where they are good. I won't name the names.
Yeah, there's a lot of counter affidavits that are admissible,
that are good,
that are admitted, that are routinely admitted all the time.
That work to make the 1801 affidavit gone, ineffective.
Right, and then parties have to do depositions, and we have to go down the road.
Move on from there. Right. But at least there's a procedural step where the defense has to take a serious step towards controverting, like putting up someone who knows what they're talking about and says it clearly.
Thank you. Any other questions? Representative Middleton?
Almost.
All right. Thank you, Mr. Chairman. So in the committee sub, I just earlier I got to read all the way through it, but in 410105 section E, it talks about the informal agreements that could occur. Are you for or against that provision? Just
I don't really have so I haven't been in the meetings to ask the question exactly what this is intended.
You're talking
to.
Yeah.
Right.
Feel free to carry on and speak.
Sure. Okay. Of course. To know what this is pointed towards. No, I don't. I mean, I don't think any of our membership would be. This is asking for agreements in place for reduction of bills.
Or any informal agreement.
Sure.
Yeah.
I just don't know what that means. But as I read it, I can't think of a reason why I would be opposed to it. E would effectively set a different bill price. I mean, if you've got an existing agreement in place to reduce a bill from 1,000 to 500, from my view, that bill is 500. So E makes sense.
Yeah, and it tracks B1 in the original draft of the bill about informal agreements to partly refund payments. So thank you for stating your position on that.
Sure.
Thank you. Anybody else? Thank you, Mr. Adams. Appreciate your testimony.
Thank you. It's my pleasure. Thank you.